So, today we are going to discuss the introduction about alternative dispute resolution. This video is prepared to give a brief idea about ADR and its mechanism. So, let's start. So, what do you mean by alternative dispute resolution? It is the processes and the mechanism used to resolve the disputes without traditional methods, that is, litigation. It involves arbitration, mediation, negotiation, and many more. ADR is designed to be more efficient in the terms of cost and time, and also less adversarial than the traditional court proceedings. So, coming to the benefits of ADR, as I already have told in the introduction, it is very efficient in terms of cost and time. Also, it is flexible and informal and preserves relationship between the parties. Also, it provides a confidentiality of the proceedings. So, coming to the main types of ADR, that are the main ones of the mechanisms that are used under ADR are mediation, arbitration, and negotiation. So, coming to arbitration. Arbitration is governed under the Arbitration and Conciliation Act 1996. It's actually the most popular mode of ADR, and as it is conducted as per the provisions of the Arbitration and Conciliation Act 1996. Coming to arbitration, in arbitration there is a neutral person who is called as the arbitrator. He is the person who hears the arguments and evidences from each side and then decides the outcome. Arbitration is less formal when compared to the other means of ADR or the other mechanisms that are in ADR, as it is very less formal than a trial, and also the rules of evidences are often relaxed. The decision that is taken by the arbitrator is final and the parties have to agree. There is generally no right to appeal in the decision given by the arbitrator. So, in case if a parties are not accepting the final decision of the arbitrator, they can go for trial. So, next one is mediation. Mediation is covered under the Mediation Act 2023. So in this mechanism also there is a third party involved who is known as a mediator. So he actually tries to make the parties come into a mutually acceptable resolution at the time of the mediation. So in order to resolve the dispute, he actually does not tries to decide the case, but he tries to make the party communicate with each other so they can try themselves to settle the disputes. So mediation may be particularly useful in the cases when they are family members, neighbors, business partners who have the dispute. So next one is the negotiation. In negotiation, there is only a direct discussion between the parties to resolve the issue amicably. It is actually often the first step in resolving disputes, as also it requires effective communication skills in order to resolve the dispute. So, ADR is not only used in locally, it is also used very well in global level. ADR is actually used in the various fields such as commercial disputes, workplace conflicts, family law, and international arbitration. It actually promotes the access to justice and reduce the burden on the courts worldwide. As we have told that in the starting itself, it's very efficient in time. Therefore, it helps the courts to reduce the burden on themselves, as the most of the cases are being amicably settled through these ADR mechanisms. So, coming to in conclusion, so alternative dispute resolution, as we have mutually understood that it is an effective means of resolving disputes in this century, as it is very efficient in time and cost. So that's all for today. Hope you got a brief idea about ADR. Thank you.